while we do appreciate those attempts, we are not waiving any appellate issues regarding the admission of these convictions.
Understood. And it may very well be that we get through this whole trial, and if there is a conviction, that it gets reversed because of things that occurred before I was ever involved in.
Do you recall there being 2 Richard Mille watches in Mr. Williams' home?
And for me, I used 2 stubs for this particular headliner.
Okay. And what was the results of your testing?
The samples from the headliner, from the Audi A5.
And we are back, Y'all, go ahead and hit that like button, y'all. You know, yesterday for the first video, y'all were liking. Second video, I don't know what happened to y'all. I mean, are y'all rocking with me? Y'all riding with me? What's the deal? Hit that like button. Y'all, I'm not going to give a whole lot of intro today. You can see from the coming up, Judge Whitaker said that this trial seems to be damaged from before she even took over. You have Weinstein, who's going in saying that there are 2 missing watches now. And then you have Hilton, who literally just cooked her own prosecution. You're going to see it the way she sets up this questioning about the GSR, the gunshot residue. She literally just cooked and probably tanked the entire Shamel Drinks prosecution. So I'm not going to talk a lot more, y'all. Hit the like button. I am going to say that. Don't forget to comment, like, subscribe. Oh, yeah. And by the way, the part where Judge Whitaker talks, that came first in the trial, but I'm putting it at the end. It's a lot of talking, so, you know, you can hang on for that if you want to see it. But we're going to jump right into the testimony. Thank y'all, and let's get right into it.
Is that, or is the 220 Victor Victor have the serial number on that item?
Is there a serial number on this?
Yes.
Yes, sir.
And does that serial number match the firearm that you collected?
I can confirm, I believe there is a slight variation between what was in the report and what is on the actual weapon, as later investigation revealed.
Can you describe that later investigation regarding the serial number?
I can. So after this weapon was recovered, taken to Atlanta Police Department property, later on I followed up on the E-Trace, the further investigation of the firearm, and was advised that the weapon had not been traced back to an original purchaser. I reviewed both my report and the photographs of the weapon and realized that due to some damage to the serial number on the weapon, which had been heavily scratched, that I had mistakenly identified one of the digits or one of the characters on the serial number from the weapon. I was able to go back, make that correction, and then complete the E-Trace report and locate the actual origination of the firearm.
With that further investigation, looking at that firearm now, is that the firearm that you collected from Investigator Clickner on March 17, 2022?
Yes, sir.
Your Honor, at this time, the state moves to tender into evidence 220 Victor Victor at this time.
No objection. All right, that's admitted.
And Investigator Belknap, was that firearm, when you had mentioned the E-Trace, was that firearm, did you check it to see if it was ever reported stolen?
I did.
And what did you find?
I contacted the original purchaser of the weapon, who advised that he had sold the weapon in a third-party sale to another party, but did have contact information for the purchaser. I then contacted that person, who advised that the weapon had been stolen from him, and an Atlanta Police Department report had been made at the time of the theft.
And did you transport that firearm back to APD property as well?
I did. At the time of recovery, I did.
Now, after you come back to APD property, did you ever take out any additional arrest warrants?
I did.
What were the arrest warrants that you took out?
I took out additional arrest warrants, if I may refresh my memory.
You may.
Additional arrest warrants for Mr. Jackson for possession of a firearm by a convicted felon, possession of a firearm during the commission of a felony, possession of a Schedule II controlled substance with intent to distribute, and 3 counts of
Yes. All right, ladies and gentlemen, before we get started back with the testimony, I just wanted to let y'all know to disregard the witness's comment about a warrant being taken for Mr. Stillwell for drugs. Go ahead, Mr. Atkins.
Thank you, Your Honor. Now, Detective Belknap, you never took out any warrants for any of the drugs related to that book bag as it pertains to Shannon Stillwell, did you?
No, sir, I did not.
Did you take out gang warrants?
I did.
And did you take out firearm and gang warrants as well on Mr. Nichols?
I did.
No further questions. Thank you, Detective Belknap.
Yes, sir.
Good morning, Detective Belknap.
Morning, sir.
We've met Max Shard. I represent Mr. Stillwell. So, I first want to ask you about the search of Jeffrey Williams' address at 355 Allison Drive on May 9th, 2022. You were present for that search, correct?
I was.
You were one of the officers executing the search.
Yes, sir.
Okay, and you didn't write a report about the execution of that search warrant, did you?
I did not.
Okay. Investigator Storno wrote a report, correct?
That's correct.
Okay, and I have asked you to review photos taken during the execution of that search warrant, and I've also asked you to review Investigator Storno's notes or report, correct?
That's correct.
And you were kind enough to do that for me, correct?
Yes, sir.
All right, excellent. And Mr. Atkins, if I could have your help displaying any images as Detective Belknap speaks about things, I'd appreciate it. On May 9th, 2022, do you recall who was present at 355 Allison Drive when you executed the search warrant?
Could you be more specific?
Okay. Jeffrey Williams was present, correct?
Yes, sir.
Martinez Arnold was present.
Yes, sir.
Diamante Kendrick was present.
Yes, sir.
Jeffrey Williams' teenage son was present, correct?
I believe so, yes.
Okay. My client, Shannon Stillwell, was not present at 355 Allison Drive on May 9th, 2022, was he?
He was not.
Okay. And you don't have any evidence at all that Mr. Stillwell has ever even been to that residence, do you?
No, I don't.
Okay. All right. And during that search warrant was sought out by Investigator Viverito, is that correct?
Yeah, I believe so.
Okay. And during that search warrant, executing that search warrant on May 9th, 2022, you all collected drugs, correct? Suspected drugs?
We did.
Delta 8 syrup as well?
Yes.
Okay. Jewelry?
Yes.
Money?
Yes.
Phones?
Yes.
Mr. Williams' cars were seized?
That's correct.
And I'm not going to ask any questions about any of those things, but you also collected guns, correct?
Yes, sir.
Okay. In fact, there were 6 guns collected, correct?
I believe so, yes.
Okay. And you have reviewed pictures taken during the execution of that search warrant, correct?
I did.
Okay. I would like to just talk about each gun individually. I can go in whatever order you have. If you could just tell us, do you have photos in front of you that display the different types of guns and the different guns that were collected on May 9th, 2022?
Yes, I do.
Okay. Could you just tell us the exhibit number of the first gun so Mr. Atkins can display it for the jury?
The first one I'm looking at is 57XX.
Okay, and that gun, from the pictures, can you tell us what type of gun, the manufacturer, anything that you can tell about that gun?
It appears to be a Glock semi-automatic handgun.
Glock semi-automatic handgun, okay. And do you have any other pictures in that sequence that reveal a serial number for that gun?
I believe so. The next one is 58XX.
Mr. Atkins, if you could display 58XX. Okay, and is the serial number BKMN536?
Yes, sir, it does.
Okay. What is the second gun that was collected?
The next one is 30XX.
You did say 30XX, correct?
Yes, sir.
Okay, thank you. Okay, is there a close-up of that gun that would help describe what type of gun it is?
I believe it's 31XX.
Okay, 31XX. And what kind of gun is that?
It's another Glock semi-automatic handgun.
Okay. Can you tell what type of projectiles or what caliber projectiles that gun fires?
It's a little difficult to tell from this picture, but from the picture alone.
Okay. Now, neither of these first two guns were the switch, correct?
That's correct.
Okay. Could you tell us what about the next gun? What number we should display?
Oh, sir, I apologize. There's actually another photo, I believe, of that gun we were just looking at, 32XX.
All right. Mr. Atkins, if you could display 32XX. All right, thank you. And for that second gun, that's the serial number?
I believe it is, yes.
And it's BNU633.
Yes, sir.
All right. How about the third gun?
The third is 21XX.
And what can you tell us about this gun as far as the caliber, or the manufacturer, or anything?
It's another semi-automatic handgun, and it appears to be a Smith & Wesson, although I can't read it on the photograph.
Okay. And is that a switch?
No, sir.
Okay. And is that the serial number? 22XX?
22XX. Yes, sir.
All right. Great. Thank you. How about the fourth gun?
The fourth is 19XX.
Okay. And what can you tell us about this gun?
And this appears to be a tan Glock semi-automatic handgun.
Okay. Is that a switch?
Does not appear to be.
The fifth gun?
That would be 15XX.
Okay. What can you tell us about this gun? Is there another picture associated with that gun?
14XX and 15XX.
14XX. Let's go with that. What can you tell us about this gun?
It's another semi-automatic handgun. Also appears to be a Smith & Wesson.
Okay. And how about the sixth gun?
This is 51, 52, and 53XX.
Now that gun, what can you tell us about that gun?
This is another Glock semi-automatic handgun, and it does appear to have a conversion switch attached to the weapon.
Okay, that is the switch.
Yes, sir.
All right, excellent. And those are the 6 guns that were collected from Jeffrey Williams' residence on May 9, 2022.
Yes, sir.
All right, great. Thank you. Thank you, Mr. Atkins. Okay, I just want to clear something up. And I'm speaking about, I'm not going to go through individually. I'm talking about all 6 firearms. Okay. Do you have any evidence that Mr. Stillwell has ever touched any of these firearms?
I do not.
Okay. Do you have any evidence that ballistically, any of these firearms were ever used in the Shamal Drinks homicide?
I didn't conduct that follow-up investigation, so I don't know whether it was or wasn't, but I'm not aware of any evidence that it was. Or anything were.
And that includes the switch too, correct?
It does.
Okay. And do you have any evidence, ballistically or otherwise, that any of these guns were used in the January 10, 2015 shooting of Donovan Thomas?
I do not.
Okay. Great. Thank you. All right. I appreciate that, Detective Belknap. I'm going to move to your work on March 17th. When you arrived on Meadowlark Drive, you saw the white Audi, correct?
Yes, sir.
It was still in the parking lot.
It was in the driveway, yes.
Excuse me. Yes, I'm sorry. The driveway. Still had the Maryland tags affixed to it.
It did.
Still had the tint.
I don't recall noting the tint.
Okay.
But I don't believe the car had been altered.
Okay. You don't believe the car had been altered? What do you mean by that?
I don't believe the car had been moved or processed at that time when I arrived on the scene.
Oh, okay. Okay. You mentioned finding a beanie.
Yes, sir.
And that is an evidence that was just admitted through you.
Correct.
Okay. So that beanie would be a separate beanie from any beanie that was collected on March 17th at 2830 Waters Road.
I don't know the answer to that question. It was collected on Meadowlark Lane.
It was collected on
Meadowlark
Meadowlark
Drive.
Lane.
Yes.
Okay. So if there's a separate beanie, if there's a beanie that was collected and put into evidence from Waters Road, there's 2 separate beanies, correct?
It would appear so, yes.
And the beanie that you collected on Meadowlark Drive was, well, do you know who was wearing that prior to their arrest?
Yes, sir.
And was it my client, Shannon Stillwell?
It was.
And you collected that beanie because you had viewed the BP video that Detective Hogan had showed you already, correct?
I had.
And you had noted that Mr. Stillwell was wearing a pink beanie in that BP video.
I had observed that, yes.
And that's clear video as far as videos go. It wasn't grainy, it was clear. And you saw Mr. Stillwell wearing the pink beanie.
Yes.
And that's why you collected this pink beanie, because he was, in your mind as a detective, it was important to collect that pink beanie because it matched what's in the BP video.
Well, I agree with that. Just to be clear, it was collected prior to my arrival and was given to me to transport to property.
Okay. And you made sure you put it into property?
I did.
Okay. All right. The bag of drugs, did you recover that backpack?
I did not.
Okay. Have you seen the video from the Phoenix helicopter?
I have.
Okay, and you would agree that it was Mr. Nichols that threw that book bag into those bushes, correct?
I would. Yes, sir.
All right. And prior to, from that video, you can see Mr. Nichols exiting the white Audi with that book bag.
That's correct.
Okay. In your experience as an officer, you have seen people flee from the police because they have drugs in the car, correct?
I have.
Okay. The FN Hurstel 5.7. Serial number 386409184 that I believe is in evidence 221 VV. That was collected by Trooper Campbell and given to you for evidence, correct?
That's correct.
All right. And you would agree that that gun is not a switch. It's not modified, not a switch.
No, it is not.
Okay. And then later, you were called by an Officer Klickner to collect an FNX 45, correct?
That's correct.
Okay. And just to be clear, the FN, going back, the FN 57 shoots 5.7 rounds, correct?
That's correct.
All right. And the FNX 45 tactical shoots 45 caliber rounds.
Yes, it does.
And those are the two guns that were located at Meadowlark Drive on March 17, 2022, correct?
That's correct.
Okay. And you collected those firearms and brought them into property, into evidence to preserve for further investigation, correct?
I did.
Okay. Those two guns, either the 5.7 and the 45, do you have any ballistic evidence linking those guns to the January 10, 2015 shooting of Donovan Thomas?
I didn't conduct any ballistics investigations on the firearms, so I don't have any ballistics evidence related to these.
Do you have any evidence that connects them to the January 10th shooting of Donovan Thomas as we sit here today?
I do not.
Okay. And how about, and let me ask you, okay, and how about this? Those two guns, the 5.7 and the 45, do you have any ballistic evidence that connects those guns to the March 14, 2017 shooting of Shamel Drinks?
I don't have ballistic evidence of any kind related to these weapons.
In fact, neither the 5.7 or the 45 even shoots 40 caliber. They're not capable of shooting 40 caliber rounds, are they?
Neither is chambered to shoot a 40 caliber round.
Okay. You, just a couple more questions. You indicated that Detective Hogan had you look at the video for the FedEx to identify Mr. Stillwell and also Mr. Nichols, correct?
I reviewed the video at some point. I believe that what I initially saw were some of the social media photos of Mr. Nichols. I don't remember what I saw initially.
Did you review the BP video at some point?
At some point, yes.
Okay. This is what I want to know. Did you ever review with Detective Hogan or by yourself the FedEx video from March 14, 2017? Excuse me, March 14, 2022.
I don't recall if I ever reviewed that video or not.
Okay, so you're not even certain if you've ever seen that video?
I don't know. I'm not certain if I have or not.
Okay. All right, thank you. No further questions.
Redirect. Oh, okay. Come on up.
I know I'm surprising the court.
Sorry.
Good morning.
Good morning.
We have met. It's good to see you again.
Yes, sir, you too.
So I have some questions about what you said today. You mentioned that to Mr. Shart that Mr. Kendrick was present in the house at Allison Drive on May 9th, 2022, correct?
I don't recall exactly what his question was, but yes.
Okay. Did you actually see Mr. Kendrick in the house?
I did not.
Okay. The 6 guns that were found in that house, in Mr. Williams' house, do you have any evidence that Mr. Kendrick was ever in possession of those 6 guns?
I do not.
Do you have any evidence that he was anywhere near those 6 guns?
I do not.
Did you take part in the inventory, possession, or transport of the jewelry that was found in Mr. Williams' home?
My role during the search was to take photographs of evidence as it was recovered.
Do you recall there being 2 Richard Mille watches in Mr. Williams' home?
I don't know if I would know those if I saw them, so I don't know if there were 2 or not.
Okay. Do you recall seeing it's a Richard Mille brand. I understand you don't know what that brand would look like, but do you recall seeing a white ceramic watch with a pink band in the jewelry that you collected, or that was collected in that home?
I believe one was. Do I remember seeing it? I certainly don't. A couple years later.
Okay. If a Richard Mille RM055 Bubba Watson white ceramic watch is not present in property today, do you know what happened to that watch?
I wouldn't have any idea.
Okay. Thank you very much.
Yes, sir.
All right, redirect.
Detective Belknap, on cross, you were asked by defense counsel about the May 9th search of Jeffrey Williams' home. Do you recall that?
Yes, sir.
Now, you actually were the photographer of those crime scene photographs we walked through, weren't you?
Yes, sir.
Now, you remember being asked questions about, I believe it was the 6 firearms that you found in that house.
Yes, sir.
And if they have any ballistic evidence to the March 14th, 2022 murder of Shamel Drinks. Do you
Correct.
recall that?
Yes.
Now, how many months later was this search from March 14th, 2022?
That'd be 2 months later.
Was Demekion Garlington arrested on May 9th, 2022 at Jeffrey Williams' home?
He was not.
Was Shannon Stillwell arrested on May 9th, 2022 in Jeffrey Williams' home?
No, he was not.
What about Miles Farley?
He was not.
What about Quarmavius Nichols?
He was not.
Now, I want to also ask you as the photographer, I'm going to publish what's marked as 64 X-ray X-ray. It's going to come up on the big screen and on your computer. Is this one of the photographs that you took?
It appears to be.
I'm going to go to 65 X-ray X-ray. Is this one of the photographs that you took?
It is.
Why did you take this photograph?
In documenting this scene, we saw this pamphlet for Mr. McMiller's funeral. Mr. McMiller was associated with YSL with Mr. Williams and had been shot and killed.
What was the date that he was murdered?
I believe it was March 11th of 2022.
And do you recall if that murder was at a house or on a highway?
It was on the highway.
Is it, I don't have pointer, but on this whiteboard, is that March 11th, 2022 and I-75-85?
Yeah, I believe so, yes.
And was Shamel Drinks murdered how many days after March 11th?
I believe it was 3 days later.
Now, I also want to ask you about, thank you, Mr. Vadi. You were asked on cross by defense counsel about a watch. Do you remember that?
I do.
Now, I'm just going to come out and ask you because we've been dancing around it. Did you steal any watch or know of any APD personnel who stole any item from that house?
Absolutely not.
Can you tell the jury the protocols that are in place when you document? Was everyone wearing body cam?
They were.
And can you describe for the jury the process y'all have when you go through that large amount of evidence on a scene like that? In terms of, do you video when you're putting it into property?
Yes, usually our body cameras will be running during the search of the home, during the transport, and at property when submitting property.
And were you all on scene or working that case for a short time or a long time?
We were out there for several hours.
One brief moment, Your Honor. No further questions. Thank you, Detective Belknap.
Thank you.
All right, any recross?
Briefly. You were asked on redirect if you're aware of any member of the APD that would have stolen this particular watch I asked you about, correct?
Yes, sir.
Do you have full and total knowledge of all the activities of members of APD?
I don't.
If this particular watch, this Richard Mille watch, ceramic watch, is present in a photograph from Jeffrey Williams' home and it is no longer present in property right now, could anything have happened to that watch other than it have been stolen or lost?
Well, no, not every item that we photograph is ultimately taken as evidence. And I think there are probably a broad number of possibilities of what could have happened to that watch other than it being stolen or lost.
Is it the practice of your office to leave behind a $500,000 watch when you're seizing jewelry?
I don't know that I can answer that as far as practices go. I have no idea the value of this watch that we're discussing, so I'm woefully uneducated as far as that goes. And I can tell you that, unfortunately, as diligent as we are, sometimes even evidence is left behind at scenes. In this case, I don't have any specific information about this particular watch.
Can you explain to the jury the procedure when you go about seizing a vehicle, such as was seized at Jeffrey Williams' home?
As far as the procedure, we would call a tow truck to come and tow that vehicle to another location.
Is there any searching of the vehicle and inventorying of property within that vehicle at the time of the seizure?
It can depend on the scene and if there's a search warrant for the vehicle or if the vehicle is accessible. Sometimes the keys may not be present, can't access a vehicle, and sometimes it's towed to a secure location to conduct an inventory or further processing of that vehicle.
If the vehicle is accessible at the scene and you have a warrant that allows you to enter that vehicle, what's the procedure for what you do with the contents of the vehicle?
Typically, those contents would be cataloged, valuable items may be secured, evidence may be seized.
Is the procedure to leave valuable items within the vehicle?
Not typically, and again, that could be case dependent if the vehicle is going to be removed to another secure location for further processing.
Okay, thank you. I have no further questions.
Yes, sir.
All right. Thank you for your time. You are excused.
Thank you.
Call your next witness.
United States calls crime scene tech Antoinette Green.
Yeah, if you could just, if you could just put them up there. I'm sorry. I'm sorry. Thank you, Ms. Dillon. Just going to put these here in case I need to ask more questions.
Okay.
Ms. Atkins, could you display if I need anything for? Thank you. Good morning.
Good morning.
Crime scene tech. You're still a crime scene tech, correct?
Well, I'm currently a supervisor, but yeah, it's.
Good morning, Supervisor Green.
Yes.
My name is Max Shard. I represent Shannon Stillwell. Okay.
Okay.
All right. Now, the work that you just testified to, you performed that work on March 22nd, 2022.
Yes.
Okay. At the annex on Bankhead Highway on Donnelly Hollowell that APD owns and stores vehicles that are evidence, correct?
Yes.
Okay. And you were not at the scene on March 14th of 2022, but you became involved when you processed these vehicles.
That's correct.
All right. And you processed these vehicles, was that pursuant to a search warrant?
Yes.
Okay. And the search warrant was obtained by Detective Hogan, is that correct?
Yes.
Who you knew to be the lead investigator in this case?
Well, investigate. Yes.
Okay, thank you. Now, when you were processing these vehicles, you were looking for any projectiles, correct?
Yes.
Any shell casings?
Yes.
Okay, well, we're going to get to the projectiles in a second. Shell casings, spent shell casings. You did not find any shell casings in the white Audi. Isn't that correct?
That's correct.
No shell casings. Okay. You were looking, obviously, for weapons.
Yes.
You didn't find any weapons in the white Audi, did you?
Yes, that's correct.
Correct, you did not.
I did not find anything.
Okay.
Yes.
All right. And you were also, as part of the execution of the search warrant, you were looking for materials or objects that could later be tested for gunshot residue, correct?
Correct, yes, sir.
Okay. So, the white Audi, you collected a cell phone from the center console, correct?
Mm-hmm.
And then you also removed the headliner, correct?
Yes.
Okay. All right. So let's just talk about the removal of the headliner. Brief indulgence, Your Honor.
Mm-hmm.
Okay. As part of a crime scene technician with the city of Atlanta, certainly now as a supervisor, you are trained in evidence collection, correct?
Yes.
And forensics, correct?
Yes.
Okay. And you are trained in gunshot residue, what it is, correct?
Yes.
Okay. And you know it to be microscopic particles that are expelled from a handgun when the gun is fired, correct?
That's correct, yes.
And it spreads in the immediate area of wherever that gun is fired.
Yes.
Okay. And you were trained in the collection of potential objects for testing for gunshot residue, correct?
Yes.
Okay. In this case, you collected the headliner from this white Audi.
Yes.
Okay. Now I'm showing you 183 VV. This is already in evidence. Is this a fair representation of what the white Audi looked like after you collected the headliner?
Yes. Yes.
Okay. And the part that you collected, is it the square on top where the sunroof is, or is it also the surrounding area that forms the border on the top of the car?
Yeah. It's been so long. Yeah. So I'm assuming that, well, I did that where I put number 1. I collected that. And if the other parts came off, I collected that as well.
Okay, so you collected it all.
Yes.
Okay. Would you like to look at the headliner to just
Okay.
confirm?
Yes. Yeah. So yes. It's yes, all the headliner, yes.
And so you would agree that it includes the part that was under the sunroof as well as the surrounding areas?
Yes.
Okay, cool. Now, the decision to collect the headliner of all places in the car, you're saying that decision was made by Investigator Hogan,
That is correct.
correct? Is this the first time you've collected a headliner of?
Actually, yes, that was my very first time collecting a headliner.
Okay. Now, when Detective Hogan requested that you collect the headliner, did you object at all to collecting the headliner?
No.
Okay, as someone trained in gunshot residue and collection and all that you know about gunshot residue, the headliner seemed like a reasonable part of the car to collect.
Well, that's what he requested to collect. He's the lead, so I'm under his direction.
And that seemed reasonable to you, though, correct?
Yes.
Okay. You didn't think it was crazy for Detective Hogan to ask you to collect the headliner?
No.
Okay. And the headliner would be, the reason you didn't think it was crazy, because the headliner would be in the area where gunshot residue would be dispersed if a gun was shot inside that Audi, correct?
Correct.
Okay, and the headliner and that cloth is different than hands, correct?
That is correct.
Okay, the cloth material based on your training experience, would be more likely to collect and maintain gunshot residue particles than someone's hands, correct?
That is correct.
Okay. So that seemed like a good idea to you to collect the headliner,
Yes.
if we wanted to get to the truth.
Yes.
Okay. And after you collected this headliner, you packaged it carefully, correct?
Yes.
In accordance with all the training and experience and guidelines that you follow in the collection of evidence,
Yes.
and you submitted it to GBI, correct?
That is correct.
And GBI being the Georgia Bureau of Investigations.
Yes.
Okay. And it would be someone from the Georgia Bureau of Investigations that I would have to talk to about whether, what the results of that gunshot residue testing is, correct?
That is correct. You have to talk to them.
All right. Oh, one more thing. In your, Mr. Atkins, could you kindly publish 374 VV? Or, I'm sorry, Mr. Abate, Ms. Hilton, thank you. Thank you. Ms. Green, this is a picture that you took of the outside of the white Audi, correct?
Correct.
Okay, and you noted that there was tint on the windows and the front and back windshield, correct?
Yes.
All right. From your inspection of this car, did you notice any damage to the tint of the front driver's side window?
No.
Did you notice any bubbling or scratches on the tint of the driver's side window?
No, I did not.
Okay. Thank you. I have no further questions.
Mr. Weinstein?
No, Your Honor.
Any redirect? No redirect. All right. Thank you for your.
Once those samplers are submitted to us, we will input them into an instrument that's called a scanning electron microscope that is equipped with an energy dispersive X-ray spectrometer, or SEM-EDS for short. And all that is just a very high-powered microscope that uses a beam of electrons instead of light, like you would usually see in a microscope that you would see in a biology classroom. This instrument will then allow us to see what's on the surface of those samplers. Any particulate matter that is there, we can see it, and then get an elemental profile of what those particles are made of. So again, with GSR, we're looking for molten particles containing all three of the elements together: lead, barium, and antimony.
Are there certain surfaces that are better to test for GSR than others?
Yes, there are. As far as like, so typically the best evidence as far as GSR is concerned is a person's hands. You can also sample surfaces such as clothing items or anything that's made of cloth or textile material. Any other surfaces can be sampled for GSR, but some surfaces don't do as well as retaining those GSR particles, and as well as making it difficult to actually sample. But any surface can technically be sampled for GSR.
And if a surface is clean, so if it's your hands, if the hands are washed, or if it's a vehicle and the vehicle is cleaned, would that prevent you from getting GSR results in cases such as that? Or can it affect getting results?
Can you get closer to the mic, Ms. Hilton?
Yes.
Thanks.
When it comes to a person's hands, if GSR particles are in fact there, washing the hands will cause you to remove most, if not all, of those GSR particles. The same can be generally said with other surfaces, especially harder surfaces. If you wipe those down or rinse those down, any GSR particles that are potentially there mostly will be lost. When it comes to clothing items or surfaces that are more cloth or textile material, most of those GSR particles, if they are in fact there, will also be lost. But we have seen that, for example, with clothing items, very small amounts of GSR can still persist even after washing your clothes.
And in a vehicle, are there certain places that, as a scientist with the GBI, that you ask law enforcement to get samples of for you to test? Are there other parts of a car that are better to test for GSR than others?
We would prefer that the headliner of a vehicle is either submitted or sampled for GSR. Again, all surfaces can be sampled for GSR inside of a vehicle, but some surfaces, the harder surfaces, just don't do as well as retaining those particles. So things such as a gear shifter or the steering wheel may not be good surfaces to sample for GSR, even though it's possible. But the headliner, maybe the headrests of the seats would be your best areas to sample for GSR.
Okay. I want to direct your attention to DOFS case number 2022-1007212, where you asked to perform any testing in that case.
Yes, I was.
And who was the agency that submitted the request?
Your Honor, may I look at my notes?
You may, if they'll help refresh your recollection.
Yes. Will they help refresh your recollection?
Yes, they will.
All right.
And I'm sorry, it was which officer?
Which agency?
Agency, the Atlanta Police Department.
And what was the agency reference number?
The agency reference number was 2207-31882.
And who requested the testing to be done?
An investigator, A.E. Hogan.
And was there a named victim on that case?
Yes, there was.
And who was that?
Mr. Shamel Drinks.
And what was submitted to the GBI for testing?
So as far as GSR analysis is concerned, a headliner that is identified as being collected from an Audi A5 was submitted.
Okay. And in front of you is State's Exhibit 388BV. And there's some fresh gloves. Tell me if you recognize Exhibit 388BV.
Okay, so this is item number 1, which is containing the headliner from the Audi A5. And I recognize it by the GBI specific barcode here with the GBI case number and item number of this particular package. I also recognize this package by the seals, where I initialed the seals here when I completed the analysis, and my initials and date when I started the analysis.
And can you walk the jury through what you did with that particular piece of evidence in order to test for GSR?
Okay, so once I am assigned this particular case, I will then go and retrieve this item of evidence out of the trace evidence evidence storage location, and then begin my analysis for GSR. So for this particular case, I was tasked with actually sampling the headliner before beginning my examination. And so I took this item of evidence into a clean processing room and began sampling this headliner using those stubs or adhesive samplers that I mentioned earlier.
And when you look inside 388 VV, do you see the adhesive stubs that you use in this case?
The adhesive stubs are not here unless they've been put inside. Oh, they're inside actually. So the adhesive stubs are a separate item that I created once I was finished sampling the headliner.
And when you say you sampled the headliner, what do you mean?
I will take the adhesive samplers and we call it dab randomly across the surface of that headliner. I used 2 stubs in total when it came to actually sampling the surface of the headliner. Keep in mind this is a sampling process. Not every square millimeter of that entire headliner can be covered by these stubs. So like I mentioned, I used 2 of these stubs and then a third stub, which was just exposed to the collection environment in the processing room that I did the sampling in, just to show that there's no extraneous GSR particles in the processing room. That will also be carried along through the examination process along with the stubs that I used to sample the actual headliner.
And is there any reason why you didn't sample or take every piece of the headliner and test every piece of it? It's a large surface area, and it is not efficient to be able to, I guess, get a representative sample of the entire surface area. But, per policy for us, it is up to the examiner's discretion. Whenever the tack or the adhesive, the stickiness is lost on those samplers, you can either stop there with your sampling or use another adhesive sampler to continue sampling. And for me, I used 2 stubs for this particular headliner. Okay. And what was the results of your testing?
The samples from the headliner, from the Audi A5, failed to reveal any particles that are characteristic of GSR.
Now, since you only tested a sample of the headliner, is it possible that there could have been GSR on the portion that you did not sample or that you did not stub?
It is possible that there is a small amount of GSR somewhere on that headliner that I happened to miss with the sampling process.
Now, I want to ask you a few hypotheticals. If a person is driving a car and they pull up to a red light, and at that red light, the same driver, I'm going to ask first, sticks their hands outside of the window and they fire a .40 caliber handgun, would you expect gunshot residue to enter into the car that the driver was in?
And it is the driver that stuck the...
Yes, the driver is the person who stuck their hands outside of the window and fired the firearm.
It's possible that a small amount of GSR could still be deposited inside the vehicle through that open window or door, perhaps, but not particularly a large amount of GSR. Most of that cloud or plume of GSR particles would be outside of the vehicle, but some of that still could be deposited inside as well.
Now, hypothetically, if a person...
Ms. Hilton, if you're going to get that far away from the mic, will you use the lapel mic or pick one up and carry it with you, please?
Sure, I'll stay by the mic, Your Honor. Hypothetically, is this good? Can you hear me? Okay. Hypothetically, if a person is driving a vehicle and they have passengers in that vehicle, and for some reason they're in the same car, the passenger shoots a gun inside of the car, inside of the same car, would you expect to find GSR inside of that vehicle?
Yes, if the gun is discharged within the cabin of that vehicle, I would expect to find GSR inside of that vehicle.
Would you expect to find more GSR in that vehicle where the gun was shot in the cabin more than the gun that was shot outside of the window of the driver's side?
Yes, it is reasonable to expect that more GSR particles will be found in the vehicle where the firearm was discharged inside of the vehicle versus the vehicle where the firearm was discharged outside of the window of the vehicle.
And in this case, outside of testing the headliner, do you know anything about where that headliner came from? Outside of knowing that it came from an Audi A5, do you know anything else about that vehicle?
No, I do not.
Court's indulgence for a moment. My last question for now. Do the conditions in which a vehicle is stored affect whether or not you'll be able to find GSR? So for example, if the gun is fired outside of a vehicle and the windows remain down, or the sunroof is opened, or the sunroof is opened and closed multiple times, does that at all affect whether or not you will find GSR inside of the car?
If the GSR particles are already deposited inside of the vehicle, I suppose it's possible that you would lose a small amount if the windows are down or the sunroof is open, just based on wind or maybe if it rained or something like that. But I wouldn't expect for there to be a huge difference based off of that alone.
Thank you so much. No further questions. All right.
Mr. Coven, good morning.
Good morning.
My name is Max Shard. I represent Shannon Stillwell. I appreciate you being here today. I'm going to ask you, let's play the hypotheticals first, and then I'm going to get into the work you actually did in this case, okay?
Okay.
All right. So you were just asked about some hypotheticals. Let's just be clear. In your expert opinion, if a gun was shot inside the cabin of a car and the sunroof was opened subsequently to the gunfire and the windows were opened and someone was driving around, in your expert opinion, the gunshot residue inside that car would remain, correct?
And this is after the gun was already discharged and the GSR was deposited?
Yes.
Yes, I would expect for there to be surfaces inside of that vehicle where the GSR particles remained, yes.
Okay, you were asked about a hypothetical where someone sticks their hand out the window. The driver sticks their hand out the window and shoots. Okay, first of all, there's a possibility that there would still be gunshot residue inside the cabin in that circumstance, correct?
That is correct.
Because it's a large plume of microscopic particles. How many particles are there typically, gunshot residue particles, discharged from a gun when it is fired?
We don't have a very accurate count on that for sure, because that's very difficult to count. But I would expect on the order of hundreds, at the very least, to be created when a firearm is discharged. Now, where those particles are deposited, that's a different story.
Could it be thousands?
It could be thousands. I can't say for sure. It's all dependent on how many shots we're talking about and how large the caliber of the firearm was.
And let me ask you this. So 3 to 4 shots fired. Outside the car, inside the car, either way. That would increase the amount of particles that are expelled from the firearm 3 to 4 times. Correct?
Yes, it would, yes.
That would make it more likely, even if a gun is shot outside a window, that there would be gunshot residue within the cabin that could be detected by you later on. Correct?
Yes, that is reasonable to expect that there will be more available to deposit on some surface somewhere, yes.
Okay, and while we're playing the hypothetical game, if someone stuck their arm out the window, the driver's side window of a car, and fired a gun, and it was on video, you would expect to see muzzle flashes, wouldn't you?
On video?
Yes.
That's reasonable to expect. Yes, with a gunfire, with a discharging firearm, yes.
You familiar with tint application?
A little bit,
You're not
yes.
supposed to down the window within 24 to 48 hours after the tint is applied, correct?
That is what I've been told before, yes.
Leads to bubbling, leads to damage to the tint.
That's correct.
Okay? If a car is collected that had recently had tint applied and there was no within hours of this alleged shooting, and then there was no damage to that tint when it was later, when the car was later processed, would that be evidence that the window was never opened to shoot out at someone?
That is outside of my expertise. I'm not a window tint expert. I know I've been told that as well before with my own vehicle, but I cannot say for sure that that is the case here.
Well, while we were doing hypotheticals, I just wanted to ask that as well. Okay. But ultimately, getting back to the work you actually did, not hypotheticals. You've done with GBI, how long have you been working with GBI?
Over 9.5 years now.
Okay, excellent. You've done thousands of tests for gunshot residue, correct?
Just over 1,000, yes.
Just over 1,000. You've tested headliners before, correct?
Yes, I have.
This isn't the first time.
No, it's not.
Okay, headliners are a relatively common part of a car to be collected to test for gunshot residue, correct?
To either be collected or someone has sampled a headliner and submitted it to us, yes.
And the reason is because the headliner, where it's situated in the car, would be a place where the gunshot residue, if the gun is fired in the car or even potentially outside the car, would be a place where gunshot residue would be deposited, correct?
That is correct. A good area for them to be retained if they were indeed deposited.
And you said retained. Retained, also, the headliners, they're a cloth fabric, correct?
That's correct.
Textiles.
Typically.
Textiles,
Yes.
correct?
Correct.
Different than a hand where you sweat and different things of that nature. These textiles tend to maintain and absorb absorb's a bad word, maintain the gunshot residue particles better than skin, for instance.
That's correct. Any item that is of cloth material or textile has the ability to hold on to or retain GSR particles better than a harder surface or better than a person's hands, simply due to the fact that we use our hands a lot. The more you're touching surfaces, you're going to lose those particles, or just washing your hands will cause you to lose all of those particles.
Okay. And in your work on this case, you took the headliner and you dabbed it with those sticky tabs, correct?
That's correct.
Did everything by the procedures as you were taught, correct?
That is correct.
You did everything by the procedures as is standing operating procedure with GBI, correct?
That is correct.
Okay. And in fact, you used that one tab, and then in fact, you broke out a second tab and continued to dab the headliner, correct?
That is correct.
How many dabs do you do with each tab?
Again, per our policy and our standards, we are to, and then it's at the discretion of the examiner, but we will continue to dab until the tackiness or the stickiness of that adhesive surface is lost. And at that point, then you can move on to a second stub or third or however many there were, or be finished with your sampling process. So in this particular case, I can't really tell you for sure how many dabs that was. Maybe a couple dozen or more than that, but I can't tell you for sure. We don't notate how many dabs there were.
All right. And you said that just dabbing, you probably didn't cover the entire surface of the headliner, correct?
That is correct.
Okay, but the reality is you don't need to effectively test for gunshot residue, correct?
That is correct. Again, unfortunately, just due to the nature of the sampling process, we can't get to every square millimeter of that entire surface. So it's possible that some things could have been missed, but this is a sampling process that is recognized throughout the forensic community and is standard for us when it comes to sampling any items for GSR.
Well, and reality is when we're talking about GSR, a gun doesn't disperse GSR to one little spot, all the GSR to one little spot on a headliner. It sends a plume, correct?
That's correct. A plume or a cloud, yes.
And so when you're saying we didn't cover every little spot, in your training and experience using, in fact, not only one tab, but two tabs and dozens of dabs, in your 9.5 years experience, you dabbed enough to get an accurate representation of whether that headliner was exposed to a plume of gunshot residue, correct?
Yes, that's correct.
You felt great about the work you did. You followed all the procedures.
Yes, I did feel good about the sampling process that I did.
Okay. Let me ask you, you've said you've been called to testify 82 times.
When it comes to GSR, yes.
Is it fair to say that the majority of those times you came to testify in court, the GSR was positive?
Is that the majority of the time? Potentially.
Okay. Has the state called you personally as an expert in gunshot residue at times when the result was positive?
Yes, they have.
Okay. And when the result was positive, you came and shared with the jury about what the results were.
That is correct.
And it was the Fulton County District Attorney's Office, just be clear, Fulton County District Attorney's Office has called you to testify about positive results before, correct?
Objection on relevance?
Overruled. You can answer.
I cannot say for sure, remembering my results from testifying in Fulton County, but it is reasonable to expect that there were some that were positive, and I was asked to testify to my results for them here. Yes.
Okay. So when the results were positive, the work was done well according to the prosecutors.
I can't really speak to.
Sustained.
Okay. All right. Now, I want to ask you, going back to another hypothetical that I left out. The hypothetical of washing. Hypothetically, you can wash your hands, correct?
That is correct.
And that can remove gunshot residue.
Correct.
And you've talked about clothing and textiles and the potential to wash textiles or clothing, correct?
That's correct.
And you also said that there's studies that show even textiles or clothing, even if they go through the wash, still have gunshot residue, correct?
That is correct.
All right, but here's the thing. I want to talk about this case. Do you have any evidence? Is there any evidence that you noted in your report, any evidence that this headliner had been washed?
There's no evidence that was noted or given to me that would indicate that it had been washed, but I would never really know for sure. Based off of what I am given to examine for the GSR analysis.
Well, I want to talk about the premise of the hypothetical. You do not have any evidence that this headliner was washed.
No, I do not.
Okay. All right, and ultimately, the results, well, we talked about hundreds or thousands, or you said maybe thousands, of particles. What is the threshold? I know that you said it's negative. The headliner was on each and every one of those tabs. When you looked under the scanning electron microscope with the beams, the electron beams, the result was negative. But what I want to know, what is the threshold for a positive?
We don't really use the word positive. It's just, is the GSR there or not? And all you need is just one particle to say that, yes, there are particles characteristic of GSR present on this surface.
So all you need is one particle under that scanning electron microscope with the electron beams to be a positive result.
That is correct.
And in this case, the result of that headliner was negative, meaning you did not even see one particle of gunshot residue on that headliner.
That is correct.
Thank you. I have no further questions.
Redirect.
Mr. Shar just asked you if there was evidence that the car was washed. Do you know, sitting here, if there's evidence that it was not washed or cleaned?
No, I do not.
Mr. Shar asked you about muzzle flashing on a video. Do you remember him asking about that?
Yes.
If the video is grainy, would you expect to see muzzle flash?
I really can't tell you for sure without actually seeing the video myself. I suppose the graininess of a video could impact that, but I can't say for sure.
And just because you don't see muzzle flash, does that mean a shooting did not occur?
I'm not really too sure on that one either.
You talked about a plume, the smoke or the cloud that comes out. The direction of the cloud, is that in the direction of the projectile of the bullet? Is that the direction of the plume that we are talking of?
So the plume or cloud is formed around the discharging firearm. Yes, the plume could have a more dense population of GSR particles in certain areas, depending on the environmental factors or what type of firearm it was. But it is a cloud or a plume of GSR particles that is created. And then you will also have some GSR particles traveling in the direction of the bullet with the bullet itself.
Can the length of time between the depositing of the GSR and the testing affect whether or not you will find GSR?
Yes, it can, just due to any factors or any events that could have occurred in the interim. So those GSR particles are deposited. Were they washed or wiped away or lost for whatever environmental reasons? That could affect the amount of GSR particles that are picked up when when it's finally sampled for GSR. Of course, I can't say for sure what happened, but those are things that can affect any GSR examination, yes.
And do you have in your notes when you tested the headliner?
I sampled the headliner on June 1st, 2022.
All right. And again, cleaning, vacuuming inside of a car, inside of a vehicle, that can affect whether or not we find GSR. Is that fair?
Yes,
Sorry.
I'm sorry. Yes, that will affect the amount of GSR particles that are there.
Thank you. No further questions.
So now we're dealing with a hypothetical about vacuuming. Do you have any evidence that this headliner was vacuumed?
No, I do not.
Okay. And when I understand that you collected the samples on June 1st, 2022.
That's correct.
When did you receive the headliner from APD?
APD submitted the headliner on March 23rd, 2022.
Okay, between March 23rd, may I approach? Mm-hmm. And this is the headliner?
Yes.
Okay, between March 23rd and June 1st, did the headliner, was it continuously, uninterruptedly kept in this evidence bag?
Based on the notes that I have and the records that I have, yes, it was.
And this evidence bag was sealed?
Yes, it was.
So no one from GBI took this headliner between March 23rd and June 1st and stuck it in the laundry?
No, they did not.
No one took the headliner and went out on Panthersville Road and ran in the yard with the headliner, just waving it around?
That's correct. No, they did not.
Okay, it was maintained in this sealed evidence bag,
Yes, it was.
just like all other evidence that is brought in to GBI for testing, correct?
That is correct.
All right, thank you. No further questions.
All right, thank you for your time. You are excused. How long shall this next witness?
Thank you.
It's relatively short, Your Honor.
Okay, let's go ahead and call another witness before lunch.
There's only a few, like the nested hearsay that emotionally argued primarily by Mr. Harvey, and what we were just discussing with Mr. Sharp that have redactions. Most of them were either in or out.
Right.
And so this specific call with, let me get a working microphone. This specific call, I listened, after Mr. Sharp sent this email, I listened to the portion of that call, and the state agrees with Mr. Sharp and redact the lawyer part. There is one portion of that call where after he tells, and by he I mean Shannon Stilwell tells Demikian, I requested a lawyer, they're talking about Miles Farley, he needs to do the same. That part I agree to redact. At the end of that brief diatribe, he says, he doesn't need to say anything. I mean, he basically says, don't tell them SHIT. And so the state is not trying to argue, someone asserting their Fifth Amendment rights, but the way that they're talking, it's not Farley speaking. It's two people talking about, hey, he doesn't need to tell them anything. The state's position is that specific line, removed from lawyers, is relevant because what is there for him to say if the murder didn't happen? That's the state, that brief portion. And so I can play it. I think the court's ruling, I don't think the court would need argument in terms of the court. It's a simple legal principle of just needs to listen to the. So I can email the court, CC defense counsel with the portion that the state is not agreeing to remove.
Okay,
So
do you want to just, is it easy enough to just play it here now?
It is, Your Honor.
Okay, you want to do that?
Yes, Your Honor.
Okay, and will that take care of it, the rest of it, y'all got sorted?
I believe so,
Sounds
Your
like?
Honor.
Okay.
And Your Honor, we're pulling up the call now, and we're going to start, as Mr. Sharp highlighted, at 3:35. In the beginning portion, the state is agreeing to redact, but just so you can hear that preliminary conversation.
So I ain't know that. I didn't tell him how to. But I say something to like, hey, bro.
And that to me, so he got to do the same shit. Don't say not one word.
Yeah.
Go down on what they try to portray or what they say, man. Don't say shit.
Yeah. So I ain't know that. I didn't tell him how to. But I say something to like.
Your Honor, we're actually going to bring it back a little bit.
Okay.
The portion about the lawyers is right before where we
All
start.
right. And that part will be out, but,
Yes, Your Honor.
okay.
All right, the record starting in 3 minutes and 20 seconds.
They're like, bro, I'm feeling probably in cat. Listen, bro, no. Just tell him for you don't want to talk, bro. Hey.
Man, listen, bro. I told Baba, I'm like, hey, tell buddy, do the same thing I did when I went in there. I told him for, hey, I want to see my lawyer. I want my lawyer. I'm going to say nothing else to me. So he got to do the same shit. Don't say not one word.
Yeah.
Go down what they try to portray or what they say, man. Don't say shit.
Yeah. I ain't.
So there's two aspects of this, and the one that I feel strongly about is when he says he needs to do just like me and demand a lawyer, and I think the
that
state's
part they agree.
Oh,
so,
okay.
Yeah.
So I mean, as long as there's no reference to Shannon, exercising his
Right.
Fifth Amendment rights, then I'm fine with it. As long as we just keep the whole thing in, and when I say the whole thing in, minus the part about Shannon demanding an attorney, but Mr. Atkins summarized it by saying that Mr. Stillwell get the word to Miles not to say, I think SHIT or something like that, but it's a little bit more. There's a little bit more context in that, and I would just ask the context.
Yeah, and so, he says, do just like I did. Are y'all proposing to play that part? Okay, so it would just start with the man don't say, okay.
Yes.
I mean, I think that part can be in, but the rest of it out. Okay. The Garlington talking to the girl, I had already made a ruling on that, right? Y'all are straight on what's in and out on that one, or we need to address that?
So, Your Honor, I believe we handled a lot that day, and so when I was telling Mr. Sharp that the court's ruling was statement against penal interest of Garlington have to redact reference from Shannon, I believe that alleviates Mr. Sharp's concern.
That's right. Yeah, that was.
Right. If I could just get a version of it, just so I can listen to it before we publish.
Understood.
Okay. All right, so I think now turn into the how to handle the convictions that are either in or going to come in for everybody. All right, so Mr. Weinstein just sent a proposed limiting instruction about things that convictions of Mr. Nichols that I agree the convictions, I mean, they were only going to come in against him anyway, so they really shouldn't be in anymore now that he's not a part of the case. So do y'all want that whole, so that's that whole first paragraph. If everybody's fine with that language, fine. If anybody wants to propose edit, let me know. Does silence mean everybody's fine, or are you just still reading it?
The first paragraph, Your Honor?
Yeah.
The state has no issue with the first paragraph.
Okay. All right. Now, on Mr. Winfrey, I looked back at the argument and then what ultimately happened with that, and the state never actually tendered his conviction.
Oh, okay.
So I guess the question then is, they were sort of left with the impression that it was a straight guilty plea and not an Alford plea, and I think that's a misimpression. Do you want me to try to explain anything to them about it now, or?
Well, my biggest concern, certainly I have a concern about the difference between an Alford and a guilty plea, but my biggest concern is, even if it wasn't admitted, the document wasn't admitted, there was testimony about him pleading guilty. And whether it's Alford or a regular guilty plea, it's still a confrontation clause issue. It's still, we've been throwing the Jefferson case around. I don't have the site handy right in front of me, but we've been arguing it. That case has come up a lot in this trial, but it's basically an out-of-court statement of guilt by a person who's not testifying. So I don't think it was appropriate, even if the certified conviction was not admitted, I don't believe it was appropriate for the jurors to even receive testimony from Detective Raisi about Jimmy Winfrey entering a plea at all. So if there's no conviction, that's good. That solves that problem. But I would ask for some instruction that that there was some previous testimony and that should not be considered. I don't know what the term I would use, but it's no longer in evidence, and it should not be considered in the jurors' consideration in this case at all.
So a couple of things. Apparently, nobody told Judge Glanville until after the testimony about he pled guilty a month later came in that the Georgia Supreme Court had reversed that conviction and found it to be coerced. So that was maybe not a great way to approach things from anybody. But the fact that it was, I think it appeared from the context that the reason it was coming in that way was there was a suggestion that somebody had offered him like a car and a chunk of money. And so the suggestion was, and so then he immediately pled guilty, and it, was some kind of like trying to influence somebody or take the heat off somebody else or something like that. Was that kind of the...
And Your Honor obviously reviewed transcripts, so I'm going to defer, but I will say this. My recollection is that when there was talk about entering a plea at all, Mr. Steele was jumping up and down from the beginning about how wrong it was.
Well, he was, but he didn't actually let the court know that the reason he was so upset about it is because it had been found to be coerced. Maybe that's in the past, that happened, whatever. But
okay, but even if it wasn't coerced, it's still, this is an overt act. And right now the jury has been informed through testimony that someone who is not testifying has gone into court and said, I guilty. I did that.
When that's not really what happened.
Well, it's not really what happened, but even if it was just a guilty plea and it was the most bland guilty plea and nothing was done in the appellate courts, it would still be improper for Detective Raisi or anyone else to say Jimmy Winfrey pled to that, because that's a statement by Jimmy Winfrey, who is not testifying, and it was clearly as part of prosecution. And it's clearly testimonial. It's a statement he made in court. So I don't, there's two issues, but I don't think the issue is just the coercion versus non-coercion and the resentencing, but the fact that there was testimony about him entering a guilty plea is a major problem. So I just think all that testimony, if there's no documents, no certified conviction, that's good. But I think that the jury needs to be instructed that any consideration, there's to be no consideration of any testimony that Jimmy Winfrey entered a guilty plea at all.
Well,
or an offered plea.
They weren't even told it was an offered plea, and I think that is relevant, that he didn't even say, I'm guilty of this. He said, I think it's in my best interest to take this plea.
I agree.
Excuse me, let me just interject just to say the case that Mr. Shard is referencing, State v. Jefferson, that's 302 Georgia 435, 2017.
So, do y'all want me to, and I'd like to hear from the state as well if y'all have something to add.
Your Honor, a couple things for the court's consideration is, one, the state agrees with the court addressing this matter. And if, as we have done with these limited instructions we're discussing now, this issue for one, the state will not be addressing or arguing in closing, which is the only other time this could come up, about Jimmy Winfrey pleading under Alford, number one. And so to cure or rectify the testimony, I think the state's position is it's prudent as we are discussing, and if we can all, both parties can try to provide a proposed instruction to the court for the court's consideration, to come collectively or ultimately as the court decides what to instruct the jury related to that matter.
All right, well, it may be today that we have to do that, right? So.
Right, and what we would ask, Your Honor, is that they be instructed that, one, the plea was under Alford, and that, two, even though it was under Alford, they should still not consider that under the Jefferson case, Your Honor.
Okay, so I think maybe the easier thing to deal with is the convictions that are going to come in against Mr. Kendrick and that have come in against Mr. Stillwell. And it looks like Mr. Stillwell's convictions were from, I don't know, a 10 SC case that was, when I looked back at this evidence, I could not even follow what was going on with that case because there were 3 different plea sheets that all said negotiated. The Senate sheet said non-negotiated, and the sentence was to different counts than the pleas sheets were. So I don't know. I would think the Senate sheet would control. Did y'all look at that? I mean, it's the certified copy, but it makes no sense. It's like the first page says he's pleading to counts 1 and 3. And then there's another one that is he's pleading to count 7. I don't know if it's count 7, but, and they're all the same indictment number. And then there's a third one that says he's pleading to count 9 or something. And then you go to the Senate sheet and that's not even what he pled to. And I don't know if it was negotiated or non-negotiated, which doesn't really matter. It's just really hard to follow what he even pled to there. One of them was definitely a gang count way back in the day. It didn't say which gang or anything like that. Then there was an 11 SC non-negotiated to burglary, a 13 SC non-negotiated to possession of marijuana with intent, and then a 19 SC that was mainly a guilty plea, but Alford on one of the many charges that was also non-negotiated. And that was like possession of a firearm by a convicted felon, which I guess maybe he was saying I didn't know it was around. I don't know. And that's why it was Alford. But I don't know if we need an Alford explanation, given that maybe I'll just, I don't know if you want me to highlight what it was or just say he had some guilty pleas.
It sounds like we have the explanation for Alford coming in.
Anyway.
Yeah, right. So I don't think we need to overly confuse
the
issues with that.
So then I think it would read, certain guilty plea convictions are about to be admitted in this case, and we'll do it right before Mr. Kendrick's pleas come in. And how are they coming in? Are you just going to, is it going to be through a witness, or are you just going to tender them?
Your Honor, I believe the state's going to just tender those into evidence.
Okay. Is it one or more than one?
I believe
for
it's
Mr. Kendrick?
I believe it's just one for Mr. Kendrick.
Okay. Well, then it would be a guilty plea and not certain convictions. A guilty plea conviction is about to be admitted in this case. A guilty plea of Mr. Kendrick will be admitted for your consideration and may be considered by you only against Mr. Kendrick and only as to counts 1 and 63. And then we would roll into, in addition, guilty plea convictions of Mr. Stillwell have previously been admitted for your consideration, and those may be considered by you only against Mr. Stillwell and only as to counts 1, 52, and 64. You may not use the conviction of Mr. Kendrick in your consideration or deliberations against Mr. Stillwell. It is not evidence of anything against Mr. Stillwell. Likewise, you may not use the convictions of Mr. Stillwell in your consideration or deliberations against Mr. Kendrick. They are not evidence of anything against Mr. Kendrick. Each defendant has a right to have his guilt or innocence determined solely on the basis of the evidence presented against him, not by what may or may have happened with regard to a criminal prosecution of someone else. And then, would this be the time to also say, and hey, by the way, jury, earlier in this case, a guilty plea conviction was entered, or guilty plea convictions of Mr. Nichols were entered. They were Alfred anyway, not guilty pleas, but and then basically say those would only have been, you could only consider those against Mr. Nichols, and so given that Mr. Nichols is no longer a part of this prosecution, they're really no longer in evidence before you?
Yes.
Okay. And then you also heard testimony about a guilty plea of Mr. Winfrey. You should not consider that against these defendants either, and just not say much more than that, or what do you think?
Your Honor, the state does believe to not highlight or revisit in the jury's minds that testimony. We're trying to tell them to disregard that. Keeping that instruction brief has merit for the purpose, and the state wanted to add, and I was trying to find, there was an older version that I believe Ms. Percifield or the court had sent where what the state wanted to include was a brief line, not that evidence has been admitted, but if there's something for the jury to know that if they find other evidence outside of the conviction for in any of those matters, they can consider that.
It's the language you would put in for Ladarius Ryan.
Yeah.
In preparation for his.
Okay. Thoughts?
My concern about that additional language, it just risks confusion of something that's already complicated enough, I think, for the jury.
I mean, I guess they can always ask about it when they're deliberating if they are wondering. Take it up then.
And I just need to add something important to the record. And Your Honor, I appreciate the attempts to craft a curative instruction.
Yeah.
I just want to be clear, very clear on behalf of Mr. Stillwell on the record that while we do appreciate those attempts, we are not waiving any appellate issues regarding the admission of these convictions.
Understood. And it may very well be that we get through this whole trial, and if there is a conviction, that it gets reversed because of things that occurred before I was ever involved in. If that's what happens, that's what happens. I'm just at this point trying to, where there may have been something that could have been handled differently, try to the extent possible to remedy it now so that when they are deliberating, to the extent possible, they're deliberating, understanding what it is they can and can't consider. But I understand that, and your objections are reserved and preserved on that issue.
I appreciate that, Your Honor, and also just as I know we have the Harvey rule, but just as a belt and suspenders, we have a similar stances.
Okay. Understood.
Mr. Sharp.
All right. Will you be introducing those convictions before lunch?
No, Your Honor.
Okay.
And they very well may not. Well, no, definitely not before
Definitely
lunch.
not before lunch.
Yes, Your
Okay,
Honor.
so that'll give me time to try to get specific language and not just what I off the cuff said just now. But, Madam Court Reporter, would there be a way for you to give me a rough, like at lunchtime, of the two things I just said?
What you just said?
Yeah. Okay, great. All right.
Your Honor,
Yes.
there was one brief matter
Okay.
that from when I was speaking with Mr. Shaw about the wiretap, there was two calls, and by my notes, they were referred to collectively as the UNC calls, and the court's instruction from my review of when we argued these was the state intended to play these without redacting UNC's statement, but the court had mentioned a instruction about, UNC's language in those calls is to give context to Garlington's response. And so the court had stated just a instruction when we play those calls that if these come in, there needs to be an instruction that it's only Garlington that you consider.
Only Garlington's statement, only Garlington's whatever he's.
Words or.
Words.
Yes, Your Honor. And for everyone's notes, I have it as the first, there's only two. PDF page number 635, which is March 17th, 2022 at 4:10 p.m. and PDF page 820, which I will get the date of that call, but I didn't have it in my notes.
Okay. So give me a heads up before those are going to be played so that I can give
Yes,
that
Your Honor.
literature. All right, anything else before we get the jury in?
Just one thing, Your Honor. When we litigated the songs, I was obviously very gung-ho about keeping them out. But I understand the court's ruling, and after my review, I just think it would be a more appropriate, and I know I was arguing only his words should come in,
Right.
but I view them as works of art at this point, and I just would like to, if we're going to publish the songs, just publish the entire songs in context.
The state has no objection to playing the entirety.
All right.
Thank you.